UK, but it was not in India, neither in Pakistan. So the class action is one where a certain percentage of a class of shareholders or a certain percentage of shareholders can actually file a suit on behalf of the whole of the shareholders of that particular class. And usually these suits are onto the management for mismanagement or onto the auditors for not being able to audit well and report the matters that they believe should have been reported and not acting in their interest. So the concept of class action was formally introduced into the Indian law in their 2013 Act. They put limits onto the remuneration of directors and key management personnel. It's based onto some averaging of the profits for certain years and the revenues, but that maximum remuneration that can be paid to directors or key management personnel is limited. There is a restriction on that. Electronic balloting, postal ballots, they all got started. Previously they were only for listed companies, they enabled it for all companies. And a very interesting concept was borrowed from the UK Act that holding companies and their wholly owned subsidiaries could be amalgamated without any regulators' involvement. So a company and its wholly owned subsidiary, they pass a resolution, the board passes a resolution for their merger, and the companies get amalgamated. They don't have to go through any other procedure, neither a regulator nor any court or any legal body. And they enabled the cross-border mergers, meaning an Indian company can now merge with a company which is a non-Indian company. So effectively, an Indian company can migrate out of India, and a foreign company can get amalgamated with a company which is incorporated in India, hence the migration from outside in there. Having the regime of foreign exchange similar to, well, I can't say similar to us, but somehow still a tighter regime, this cross-border merger still requires the approval of their reserve bank, the central bank, but at least the provision is now there into the law that it can happen if all regulatory approvals are there. And very interestingly, they created a national company law tribunal. There was an appellate tribunal that was created for that, and this was given all the jurisdictions which was there with the High Court before. So now under their law, High Courts have no jurisdiction at all. It is a quasi-legal or judicial body, National Company Law Tribunal with the appellate forum. And after that, the final appeal lies with the Supreme Court. So the whole jurisdiction of the High Court got eliminated. Came up with associated companies definition to the significant influence, and included the mandatory CSR for companies having prescribed net worth and revenue, where they have to form a policy in the shorter term, and in the longer term, just like in Mauritius, they also have to start allocating a particular percentage of their profits to the CSR activities as per their plan. So these were the key changes which took place in 2000s, and this law was made in 2013 in India. And a lot of the changes which are there now in our acts, law that we'll see revolves somewhere around the concepts which they brought in. The objects for the Pakistan law reform were primarily this. Let's have a short look so that we can understand when we see the exact changes. One, the use of technology and electronic means to be enhanced as much as possible. The second, third, fourth, safeguarding, everything has always been there, that we want to safeguard the minority interests. Providing alternate mechanism for expeditious resolution of corporate disputes. So whatever the corporate matters now keep on being there into the courts, and for years and years they take, there should be some mechanism through which there should be a resolution which is expeditious. And abolishing unnecessary requirements and softer regime introduction for the company. So this was the overall objective with which the changes were brought into our corporate law here. So with this structure, let's move forward and start looking at the key changes. I've tried to color code some of the things that we will explain so that we can directly relate to whether it's a change in the first draft, second draft, whether it is an ICAP's present comment or some future comment. So I'll be explaining that. So let's first go through with the corporate matters changes which are taking place. We all have seen the memorandums of companies which have pages and pages in respect of object laws, so that we don't miss out on anything that we cannot do tomorrow. So there is a change proposed in the law now that will require that a company can do everything which is required, which is not specifically disallowed by any law. It's just that they will have to bring in one main object, but that does not mean that other than that they cannot do anything else. So unless something is restricted by a law or by a regulation or something that requires a specific licensing, everything a company will be able to do without having that explicitly into their memorandum. So the memorandum is expected to be just a one-pager from now on. And the second thing, the subscription which is put in memorandum, there has been no requirement as to within which time that has to be paid to the company. And a lot of my friends sitting here would have actually seen situations where a company gets incorporated, a year end comes, and the amount of share capital is not a nominal one, but no payment of the share capital has been made till the year end to the company. So there is a time which is now being proposed that after 15 days of incorporation, the amount with which the company gets registered has to be paid to the company, and the auditor of the company is required to certify that within certain period of time after his appointment. So this matter has now been formalized, which is a positive thing, that a time limit has been prescribed in that form. Second is the use of technologies. One, enabling provisions have been brought in that you can service the notices to members and to the registrar and commission through electronic means. Secondly, you can participate into the meetings through video link, and the voting at meetings can also be electronic. Some of these were already in the process of happening in Pakistan through certain regulations for listed companies specifically, but the enabling law was not yet there, so the enabling law is being provided here. But interestingly, two powers have been given to Commission. First, to notify where they can require that all the returns which are to be made to them have to be online. And they are bringing in the concept of licensed intermediaries for companies who do not have good IT infrastructures. So it is expected that in some time the manual return filing will not be there anymore, and all the companies will be required to file the online returns with the Commission. And secondly, all the notices which are to be sent to the members, the Commission also now has a power to notify that from a certain date onwards, all these will be sent electronically, and anyone who requires a physical notice will have to bear the cost for that. So these two very enabling powers have now been given to the Commission in this draft. Now, interestingly, for the same use of technology, another thing that they are bringing in or want to bring in is that they want to dematerialize all the shares. If you see, the color here is red, not black, with which I have written this. So effectively it is a second exposure draft, second draft that they are bringing in. It was not there in the first one, so ICAP has not yet commented on to that. They have brought this into the second draft that they have shared. And within 4 years of the act coming into force, all companies, public, private, all will have to have their securities into dematerialized form, into the book entry form. And second, all the new incorporations from under this act, after it becomes applicable, from day one the companies will have to have their shares in the dematerialized form. Now, although on one side it is pretty positive, that is the use of technology and the physical shares and all that hassle will not be there, but of course, secondly, the law that we have about the central depositories, that now has a provision that if a transaction goes through the depository, it cannot be reversed. So if some shares are transferred even fraudulently to someone, the transaction cannot be reversed, only the damages can be claimed. So the risk attached with this one maybe also have to be taken care of, especially in case of the private companies. In listed companies, it's not such a big risk because nothing can move through CDC unless there is a market transaction or there is a specific approval. But in case of unlisted companies, and specifically private companies, some enabling law will also have to be made there, so that this limitation of depositories law also gets addressed. Other interesting ones. For the private companies, they want to bring in a situation, or rather a requirement, that whoever wants to sell the shares of a private company mandatorily has to offer these to the other members of the company. So if I am a shareholder of a private company, I will have to offer these shares to the other members if I want to sell any of my shares. And I can only go out if all the members say that we do not need those shares. The ICAP had proposed to them that there should be a mechanism into the articles of the company. If the articles provide for a mechanism how there will be an exit, say there are certain tag-along rights or something else, let that be followed. And if there is no mechanism in the articles, then okay, fine, it should be there in the law that you have to offer it to the other one, so that private companies at least have the opportunity to articulate the exit of the shareholders. But in the second draft also, the amendment has not been made and the provision stays in the draft. This green effectively means that this is a proposal that has already gone by the ICAP, discussed with the SECP also. And second thing that they are bringing in is that there are a lot of issues in terms of inheritance, and there are certain key court decisions also that you cannot transfer the shares to nominee. Although the corporate law allows a shareholder to give a nomination in whose name the shares have to be transferred by the company in case of death of that member. What they're trying to bring into the law is that fine, the nominee will be the shareholder or member, but he will be a trustee for the legal heirs. Now, interestingly, there is another provision in the corporate law that explicitly states, and it is going to stay, that the trust shall not be recognized by the company. And here in this provision, they want to bring in that the trust, the nominee will be a trustee for the legal heirs, whatever is the law. So their argument is that we want, since the courts do not work on the inheritance well, and there are a lot of delays and stay orders, so we want to bring in. So its inherent conflict will come. So the ICAP had proposed that let this remain here. The corporate regulator should only be concerned, and the corporate law should only be concerned about the creation, management, and the winding up of that artificial person. Rest all is the interaction of other laws. Inheritance law should not be taken care of or tried to be taken care of into the corporate law itself. But in the second draft, this provision still is the same. It has not been changed. Journal meetings, a very good, I would say, change that they are bringing in, that in case of unlisted companies having up to 50 members, companies can pass a general body resolution also through circulation. So instead of having an EOGM, which is an emergent EOGM, if you have less than 50 members, all members sign a resolution, and that resolution will be passed by circulation. And the notice period is also proposed to be reduced from 21 days to 14 days. Single member company we had introduced in 2002 with minimal changes. So the requirement of holding annual general meeting, extraordinary general meeting, election of directors was still applicable onto single member company, which used to be a paper exercise. So in the present law, it's proposed that all those requirements for the SMCs will go. And there should be facility for attending the meeting through video link, and rather they are coming up with the requirement that for listed companies, if in any city there are more than 10% of the shareholders, then the listed company will be required to offer a video link in that city for members to come in and attend the meeting. The proposal from the ICAP was that it should not be binding from the day one itself. Leave it for the companies to decide depending on to their circumstances for some period of time, because having this requirement from the day one is expected to have a lot of issues into the listed companies' general meetings. But the requirement stays. The original requirement was some X percent, I cannot exactly recall, I think that was 15%, but in the second draft, they have reduced it even to the 10%. With the further issue of share capital, this was another area where there used to be a lot of litigation. A company issues further shares, offer letters are sent, some shareholder claims I never received it, the other person has already subscribed to the shares and the shareholding has changed. There was no minimum maximum period that was required to be given to members for deciding whether they want to subscribe to the new shares or not. So that is now being proposed, that a 15 to 30 years period should be there whenever you are issuing right shares for the offer to be accepted or rejected by the shareholders. And the period will have to start from the service of the offer letter to that person. So the company has to ensure that there is the service has been done, service of the notice, and then there is a time period of 15 to 30 days for that. Interestingly, in the 1984 law, if a shareholder decided not to take up his shares in right, by law the right to offer these shares was given to the board of directors. Although by practice the rights of listed companies were being sold, but there was no concept of renunciation in the favor of someone else. So that legal lacuna is now being settled, and the concept of renunciation of the rights of listed company is being brought up into the law, that the listed companies shareholders can renunciate their right in the favor of someone else. In practice this was already being done, even the rights were being traded, but there were legal challenges on which I personally know there are few cases pending in the court, so the enabling law is now being made for that. And very good requirements of conversion of loans, which was not there before, are now being taken up, that if there was an agreement under which the conversion was there, you can issue the shares without doing the right and without the approval of the SECP itself. We could still do it now, but to do this we had to go through the SECP again to get the approval of the issue of right shares without approval of further shares without the rights. So that now is proposed to go. So this is a good one. The institute had proposed that in case of private companies at least, the articles should be able to have a mechanism as to who will have the right to get the shares in case of new issue of shares. And why? Because a lot of companies are now going into the rounds, the first round of the share capital, they are raising some money for the project. Depending on the success of the project, they bring in other investors with different streams of the returns. So a lot of private companies require that to be there. So the institute had proposed that in case of private companies at least, the mechanism, the companies should be able to have a mechanism in their articles as to how rights will be offered. But it has not been changed in the second draft even. And this is a very interesting one, the exemption of the from the further issue and the rights. I have let all the wording to be here because it was a very interesting wording, which says that in case of a public interest company where it has obtained a loan from the government, and the government has defined to be any government or a body corporate controlled by the government. So if I am a public interest entity and I have taken up a loan from another body corporate which is controlled by the company, by the government, not necessarily just the government, even a body corporate that is controlled by the government. Government has a right that if they think in the public interest this loan has to be converted into shares, so unilaterally they can decide that this loan will be converted into the shares of my company. At what price? Whatever they want. SECP believes that the English just allows this right to the governments, which is the federal government and provincial government. But the way it has been articulated that the government includes even the body corporates controlled by the federal government and the provincial government.